Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me today, my good friend and special guest, Russ Cook with Cook Tillman Law Group over in Brentwood, Tennessee. Just rolled right off the tongue that time. All right. We were talking about common terms. One of the things, you know, from a practical standpoint, Russ had just laid out for you about the different parties to a trust, okay, starting with the trustor. So here you are, you're thinking of going and setting up a revocable trust. You're going to meet with an attorney to do that. We're going to help you with that part as well, by the way. And now the attorney's basically saying, okay, you're the person that's come in to get this trust set up. You therefore are the trustor. You created it. And in the trust document, there's going to be certain things about that with regard to things you can do, like it's revocable. If you wanted to, you know, throw it away and start something different, you can do that. If you want to change it or amend it through your lifetime, you can do that. The next part is that of the trustee. So you're also going to be your own trustee of your trust, meaning you're going to be the one that manages it and, you know, basically controls everything. So you've got an account set up, a trust account set up at a brokerage firm as an example. You as the trustee are the one that sign any documents, that can take money out, put money in, do whatever you're going to do with regard to managing that trust. And then you're also the beneficiary, meaning that the only one that receives any benefit from those trust assets would be you. Okay, so, and for a couple, you know, just double that up. So for an individual, which is what I'm talking about initially, you're going to be trustor, you're going to be trustee, and you're going to be your own beneficiary. Then you're going to set up in the document, right? And typically it's for, you know, say you're leaving it to a child, or you've, you know, or more than one, and they're now going to be the successor trustee. And this also, if you became incapacitated, you're also choosing who you want to manage your assets for you. Now, within a trust, you've got a lot of flexibility, and this is one of the things, Russ, the way trusts are used, the things that you can do with that trust. So for instance, let's talk about the differences when it comes to estate planning. Let's talk about the difference between a revocable trust and an irrevocable trust.
Yeah, the revocable trust is a trust that allows you to change the terms or get rid of the trust entirely if you decide, as Hank had pointed out, that you want to go in a different direction with your estate plan. A revocable trust is normally thought of as a will substitute. It's basically taking the place of your will. It allows you to transfer your assets at death as you see fit. An irrevocable trust is one where the terms cannot be changed. And typically, in our scenario, the trust that you create during your life, when you pass away, it becomes an irrevocable trust, meaning that you're no longer alive, so you're no longer there to revoke it. So at that point, the successor trustee is bound to take care of your wishes or do your transfer your assets according to your wishes, and no one else can come in and change those terms. You don't want anyone changing the terms anyways.
Right.
So that's clearly the intent when it comes to the difference there. Some folks set up irrevocable trusts while they're living. That's where they decide, hey, I don't want the trust terms to change. I'm trying to deal with a specific situation, like I'm trying to either get assets out of my estate for estate tax purposes, I'm trying to get assets out of my estate to qualify for Medicaid, I'm trying to make gifts to my kids, but I don't want to give them the assets directly. That's when you would create an irrevocable trust, and in most cases, you would have someone else be the trustee and beneficiary. There are some instances where you would retain those rights, but normally that is in a special circumstance. It's not something that we deal with day to day.
And this is one of those, you know, there are some uses when it comes to your estate planning, is understanding the difference between, as Russ alluded to, your revocable trust when you pass becomes irrevocable. In particular, if you're going to, you know, keep that trust around, right, to take care of children and grandchildren, this is a time when now it's going to have its own separate, it's going to go from your Social Security number when you're gone, of course, to its own separate tax ID number. Now there's a lot of different strategies that then come into play of how you can still minimize taxes, get the asset protection. There's a lot more benefit, if you will, over the long term for that. But they have different uses. So revocable trust versus irrevocable trust have different uses when it comes to estate planning. So one is the kind of evolution that can occur. But let's talk, Russ, about uses for revocable trust when it comes to estate planning. One of the first ones people typically want is that of avoiding probate. And in particular, if you've got property in other states, that can be a very important benefit.
Yeah, because really what you're doing when you create a revocable trust is you're creating a bucket to put your stuff in now. And when you pass away, that bucket gets transferred to whomever you want to take care of it when you pass away. And of course, it's important to fund the trust while you're living so that all of this can take place. So if you have assets outside the state of Tennessee, like real estate mainly is what we're talking about, you want to make sure you transfer those assets into the trust while you're living. That will avoid a double probate, because otherwise you would file your will here in order to get the process started, and then you'd have to find an attorney, or your family would have to find an attorney in the state where the real estate is located in order to be able to transfer that asset. It streamlines the process. You can go, when you pass away, if all your assets are already in this bucket, so to speak, then the person taking over, the successor trustee, can carry out your wishes immediately. If they need to sell the house, if they need to go ahead and sell the contents of the house, that all can be done fairly quickly, because you're not waiting on a court proceeding in order to give that person, the trustee, that is, the person taking over, the right to go ahead and take care of these assets for you. Mm-hmm. And if you become incompetent or otherwise cannot manage your own assets, then the trust is already there, this bucket's already in existence, you're the beneficiary, you have someone else take over, and they're the one, you have the person you want. That's important. You have the person you want to take over those assets and make sure they're handled to your benefit while you're living. So this is a document that certainly can solve a lot of problems that people normally would have if they didn't have any documents, or maybe some even if they were to have a will.
And this is the thing when you're thinking of, practically, again, just to break that down. So imagine, God forbid, again, you have a stroke, right? You're not able to take care of things. You're choosing who's going to pay your bills, who's going to, manage your affairs during this period of incapacity. As opposed to someone some family member or whatever having to be appointed conservator and report to the court what they're doing. For a couple, as an example, this can be particularly onerous in that, your wife wouldn't be able, as an example, to access funds to pay the bills and take care of things. She'd have to go to be appointed a conservator, report to the court what she's doing with the family assets, and of course have the expense of accountants and attorneys and the time delays and court costs that all go with that as well. So it's so important. This is where both having a trust can be helpful, but also not to forget these power of attorneys that go with that. Revocable trusts, again, they don't change. You're still under your Social Security number, so they're not changing anything with regard to taxes. Now, an irrevocable trust, and the way that they can be used, and one of the more common ones, Russ, and we haven't, because of the estate tax exemption being raised, haven't used as much, but we talked about irrevocable when someone passes, but what about someone that might set up, let's say, an ILIT, an irrevocable life insurance trust?
Yeah, there are many reasons to go ahead and set up irrevocable trusts while you're living, and a lot of them have to do with special circumstances that you might run into. For example, if you are in a situation where your assets might be subject to estate tax at your passing, and the exemptions have been very high. They are going down. In 2026, we're each going to have roughly a $6 million exemption. Between a couple, that's $12 million. Well, if you add to the assets in a couple's estate the death benefit from life insurance, sometimes that pushes the estate over those numbers. And life insurance death benefit is counted when they determine what the size of your estate is. So what a lot of folks will do is they'll take that life insurance policy and they'll transfer it into an irrevocable trust that takes it out of your estate for estate tax purposes and yet allows for your family to still benefit from the death proceeds that you're passing. Because that asset, that insurance policy is not really an asset that you can use while you're living. At least most cases, it's not set up that way. And so transferring it into the trust doesn't mean that you're losing any benefits that you would have otherwise had. All you're doing is removing those death proceeds from your estate. And of course, the ideal situation is to set up the trust and let the trust buy the policy from an estate tax standpoint. But that's a really important tool to use when you have assets that are going to push you over that. So remember, the insurance is included.
This is one of those areas that, being forward thinking, we tend to think in terms of, and I cover this with clients all the time because they're coming in as an example. Dealt with a gentleman, actually a couple that's very similar in the past couple of weeks, and one of the things that came up there is I think their estate was somewhere between $4 and $5 million, so they're under the exemption. However, when we look forward, and in fact, as Russ was just saying, when the sunset provision occurs and the estate tax drops from the current $12 million exemption down to $6, okay, in 2026, well, what's your estate going to be worth in just 4 or 5 years? And then let's think even longer, of course. How old are you? If you're in your mid-50s or mid-60s, let's say mid-60s even, right? You're just getting ready to retire and put all these things in order. Well, you're likely to be around for a good 20 plus years. So now what's your estate going to be worth 20 years from now? And how's that going to be impacted? And if you've got life insurance, let's say as an example, your estate is already, we're projecting that your estate will be worth $6 million, and you've got $1 million in let's say I call $1.5 million in life insurance. That 1.5 is basically going to create $1.5 million of your estate that's going to be subject to that estate tax, and I believe the rate's what, 40%, Russ?
Yeah, 40%.
40%. So, so that's $600,000 in tax, right, on that 1.5 million life insurance policy. In other words, would create $600,000 tax liability that if you just set up an ILIT, an irrevocable life insurance trust, and you put it in there, it's going to be taken out of the estate, still go to your beneficiaries, but on a completely tax-free, no federal income taxes, and now no estate taxes as well. $600,000 in savings, something worth looking at, right? And also, this is the part of what I do, and I'm going to talk about this after the break a little more, about how estates grow. So when I'm working with, when someone comes in for the first time, we're setting up their financial plan. A big part of that is I'm able to show you your financial future, how much you're going to be worth 10, 15, 20 plus years down the road, and then what does that mean with regard to your estate planning? Important to know, right? All right, first for the break. Join us here. We'll be right back on the Retirement Report.